You may have also had an issue before with Mr. Shemke and with Mr. Westmoreland. I believe Mr. Serrano represented you in another matter, and that appeared to be fine, correct?
No, it wasn't fine. I just didn't say anything. You should get some more diverse attorneys in here instead of certain ones that don't, I watch how they treat certain people that come in here. You know what I'm saying? I watch the conversations they might have with a person that's not of color and a person that is of color. I watch how the tone in your voice. I can see it. I'm not blind.
Okay.
You know what I'm saying? So, I just want to be treated fairly.
Sir, just so you know that any attorney of any ethnic persuasion, please don't interrupt, of ethnic background can certainly apply to be on our MIDC council. That's perfect.
You need some people that's better that deals with.
I'm tired of
Just a moment, Mr. Gopal, just a moment.
That's all I'm saying.
Mr. Because something you say could be used against you.
Mm-hmm.
So that is why I indicated if your attorney suggests that you speak.
I'm just saying the Michigan Tenure Commission needs to hear about this.
Okay, now I'm holding yours contempt. I've already indicated that you are not to interrupt this court, yet you have continued to do so. I've given you one chance. I've given you one chance right now. The court is going to indicate pursuant to MCL 600.1701 that you are engaging in disorderly, contemptuous, insolent behavior during the immediate.
Brace yourselves for a double feature in the realm of the Honorable Judge Elizabeth DiSanto's courtroom. Today, we bring you not one, but two cases that took an unexpected turn, leading to a dramatic contempt charge. As our spotlight falls on an African-American defendant whose distrust in his court-appointed attorney takes center stage during his initial appearance. Allegations of inadequate defense based on the defendant's skin color turned the courtroom into a powder keg. Sparks fly as the defendant and his lawyer engage in a heated argument, laying the foundation for the chaos to come. In the second clip, we revisit the defendant's subsequent appearance, where tensions escalate, pushing Judge DiSanto to her limits. As the verbal sparring reaches the limit, the gavel comes down in a thunderous declaration of contempt. Why did it come to this point? Could there have been an alternative resolution? Stay tuned to unlock the mystery to these captivating cases.
Mr. Randolph insists that he wants to make a statement that this court dismissed the charges because there was no complaining witness present today. There was no complaining witness present at the previous pre-trial. And I explained that this complaining witness did not have to appear at the pre-trial. And he, insisted that I should make a motion to dismiss based on what I told. That's, as explained to him, that is not the issue.
Okay. All right, and so Mr. Howard Randolph?
Yes,
Hold on. So because you have your mask on, I need you to go directly into the microphone so you can hear yourself over the speaker. Hold on, please. Let me finish because we can only record one at a time. So the way you were just talking in the microphone was perfect because we could hear you through the speaker. So if you can make sure you're doing that again, okay? Right. And so what would you like the court to know?
All right, of course, no, yes, I do want it to be moved for dismissal.
No, stop, no. Listen, hold on, sir, you're in court.
Okay.
So you may think it's bull crap, you may think it's whatever, but you're not talking to the court like that. Okay, so.
I disrespect the court's free country. Say what you want to say.
Not in court, you're not going to address the court with those type of words.
What type
okay?
of words?
If you think that the charges don't have merit, that is certainly your opinion. You have that prerogative, sir, to have that opinion.
It's the fact.
There is not a motion to dismiss in front of this court, so I'm not going to entertain that at this time.
Okay, thank you. But I like to go with different counsel because me and him is not seeing eye to eye. We argued the last time I was here. I'm not being represented fairly or properly by this gentleman right here. And I don't want, going to trial. If I have to go to trial and be enforced into this, like how I'm the last person to be seen when my court date is at 9:30. So since I'm being treated unfairly, I would want a chance to be treated fairly, and which means I want to go with another attorney, not one that's working with you guys or the prosecutor. So if that's possible, can I get a change of attorney?
Hold on.
Because he's not
First of
doing
all,
his job. He
first,
don't communicate.
sir, just one moment, just
I
a
don't
moment.
have a representative.
First of all, sir, you're not the last one to be called. We have somebody up there that still has to be called. So you're not, excuse me, you're not the last person to be called. And let me just indicate this, all right? In full transparency. So you're scheduled at 9:30. The only individuals that were taken prior to you were those that were set for exam and waived, and those that were in custody that this court is required to handle because we're tying up the cameras of the jail or whatnot.
Right.
Okay, and let me just say this also. When there are, because on this, when we have this docket, right? We hope it's going to go perfectly. It doesn't. People are late, attorneys are late, everything gets pushed back. We had a delay with our recording system. So there isn't any personal reason as to why your matter was called 3 hours later.
Just seemed like it to me.
I understand that, but there, hold on, just one
So,
moment.
I mean, I don't want to be my attorney.
Stop, as I've already indicated, one can talk at a time, do not interrupt.
I was talking.
I was talking, do not interrupt. You have been here previous times, you're not always the last one called or anything of that nature, okay? So, if you would like to have a different attorney, we can certainly accommodate that, okay? Now, we will then adjourn this matter, we will not set it for a bench trial, we will adjourn this matter. And I believe that you may have also had an issue before with Mr. Shemke and with Mr. Westmoreland. I believe Mr. Serrano represented you in another matter, and that appeared to be fine, correct?
No, it wasn't fine. I just didn't say anything. You should get some more diverse attorneys in here instead of certain ones that don't, I watch how they treat certain people that come in here. You know what I'm saying? I watch the conversations they might have with a person that's not of color and a person that is of color. I watch how the tone in your voice. I can see it. I'm not blind.
Okay,
You know what I'm saying?
Sir-
So, I mean, I just want to be treated fairly.
sir, just so you know that any attorney of any ethnic persuasion, please don't interrupt, of ethnic background can certainly apply to be on our MIDC council. That's perfectly fine. As of now, we have 4 attorneys that are on our MIDC list through our region. Okay, that's what we have. So
Well, you need some people that's better that deals with.
I'm tired of this.
just a moment, Mr. Gopal, just a moment.
That's all I'm saying.
Mr. Howard Randolph. You're continuing to make accusations about Mr. Gopal. Just one moment.
I'm a client of this.
You're-
I'm telling you, I'm not being represented.
You're continuing to make allegations about Mr. Gopal, so I'm going to give him an opportunity to respond. I'm going to adjourn this date. We're going to provide you with new counsel,
Thank you.
which will likely be Mr. Serrano, but I'm not positive.
I don't want him either. I'm not gonna.
Then, sir, you certainly have the right to retain your own
What about
attorney.
The black lady that was on here that y'all had called me one time before. Y'all could court appoint me to one time, but I had retained an attorney, so I didn't use her.
Okay,
Person of color, anything, I
Sir,
don't hear someone that acts like they're not racist,
This-
just anything.
sir, to make the allegation that Mr. Gopal is racist, number one, I don't hear any foundation for that, and I'm going to give him, please stop interrupting me. Stop interrupting me. Any of the attorneys that were on Zoom earlier are felony court appointed attorneys. And fortunately for you, perhaps, or not, this is a misdemeanor, not a felony. So those attorneys are not necessarily appointed on these misdemeanor matters. You certainly have the right to go retain your own counsel.
I know you do, but I don't have the money to right now. Why, I don't wanna give that money up for something that's not true and something that's petty.
Sir, Sir, if you have the money, if you
No, I
have,
didn't say I had the money.
You
I
said
don't
you don't
have- I
wanna
have
give it up.
kids. I got 4 kids. I'm not gonna give it to a court system to play games with and so y'all can feed your families. No, I want to write attorney, somebody who's gonna help me, who gonna do their job. I don't want somebody who's not gonna do their job.
Okay,
I want
sir.
someone-
Sir, let me just clarify.
I'm tired of this, Brian.
That's
Mr.
what-
Gopal, just for a moment.
That
Sir,
right there.
sir, just for a moment.
Look at it. Come
That
on.
has nothing to do with color. Stop right now. That has nothing to do with color
What is-
at all. You are making claims, stop interrupting the court. You are making claims about Mr. Gopal's ability, about you're making claims that he's racist of some, and he's not stating anything. I'm not giving him an opportunity to respond.
Give them-
So stop interrupting the court. I will give him an opportunity to respond, but the fact that he's getting frustrated with your comments doesn't have anything to do with being racist, not racist, or anything of the like. So what I'm indicating to you, sir, is you have a perception that appears to be flawed. You think giving your money to the court system, to this court, is allowing everybody to feed their kids.
It's taking food off my kids' plate.
Sir, you have the right to retain your own attorney. If you have the ability to retain your own attorney, then you wouldn't qualify for court-appointed counsel.
I don't have the ability to do that, so that's what I'm saying. I want a different court-appointed attorney.
I said you will get a different court-appointed attorney.
And I was recommending the black lady that I was seeing on here.
And I've indicated that attorney is not one that I have the
You said
authority.
she was a felony, okay.
I do not have the authority to appoint her in your misdemeanor matter.
What about the other one that represented me for Pam's mother? What about him? He was.
Mr. Serrano, I already indicated that was,
Yes, Mr. Serrano was here right now. Have you said guy?
yes.
No, I don't know him. I'm talking about the one that represented me in the looking case, when they said I looked at somebody. And y'all hit me in here for looking at somebody on a probation violation. That guy,
Was it Mr. Westmoreland?
probably so. I don't know. I know it wasn't him.
Okay, well, I guess we can look that up and see who that was.
Just wanna be treated fairly, that's all.
Okay. All right, everybody wants to be treated fairly. Mr. Gopal.
Your Honor, any claim that I did not treat him fairly is absurd. First met with Mr. Howard at the previous hearings, and at that point in time, we discussed the charges against him. We also discussed the allegations, and I had an opportunity to discover. This is a matter out of Riverview, but it's a state case. The first words out of his mouth were that I was being racist when I was talking. That was the very first time. I told him that has nothing to do with race. I am not a racist, and I'm here to try to help you. All he wanted to do was say, there are no witnesses here, and this case should be dismissed. That's what I want you to do. I explained it at that time, the procedures, that we would get the discovery materials, and we would then have it set for another pretrial. Finally, we got that taken care of. I filed for the discovery. I went, delivered it to the Riverview Police Department, and obtained the discovery. I then sent the discovery to Mr. Rashid Howard Randolph. And when I spoke to him today, with 2 emails reminding him of our hearing today. When I spoke to him today, he said, well, I never got it. You never sent it to me. I turned around, showed him the email, and then he went on the phone. He said, oh, here it is.
They were in my spam.
Don't interrupt, please.
It may have been.
You made your allegations. I did not allow Mr. Gopal to respond or interrupt, so we're going to have likewise this way.
I've done everything I can to try to represent him in a fair way. It's not my fault, Your Honor, that the people are not going to dismiss this case. I spoke with Mr. Kazak this morning, informed him it was my understanding that the complainant in this matter had contacted the court, or the prosecutor's office, or the prosecutor had contacted them, her rather, and he indicated, yes, she did do that. he also indicated to me that she did not want to prosecute.
Well, that's not quite, yeah, yes, she had mixed feelings about moving forward.
Okay.
She went under oath. Did she say?
With Mr. Howard Randolph, please, not right now, not right now, not right now.
I'll note, Your Honor, just Michael Kizak for the people, Your Honor, I'll note that people in the state of Michigan bring the prosecution, not the complaint, so whether or not the complaint wants to move forward on the case or not is to some extent immaterial. People at this time are going to be moving forward on the prosecution, defendant, even if the complaint has mixed feelings about it.
Okay.
Okay,
And that's what I tried to explain to Mr. Howard Rashid this morning.
Did not explain that to me. Did not say that. That is not the case. That's not what you said.
Yes, it is.
hold on,
And
hold
I'm
on,
tired.
hold on, hold on,
You
hold
tried
on,
to.
hold on,
What did I do?
hold on. Mr. Howard Randolph, what is it that Mr. Gopal said to you regarding the fact that this matter was not going to be
I'll let him know
dismissed?
that I was-
Let me finish before you interrupt. Regarding the fact that this matter would not be dismissed today and that it was going to be set for a bench trial. What was it that was said to you?
Nothing really. He didn't say anything. I was told that I was under the impression through another attorney that was saying that she had contacted them and said that she wanted to drop the charges.
I mean, through another attorney,
Well, yeah, mutual attorney, yeah.
a mutual attorney. Is-
An attorney, just know that, and who will say that, and. he
An attorney that was here today?
Attorney. what you mean?
Was the attorney here today?
No, it's in a whole other court district jurisdiction.
Oh, the matter out in
This is
Macomb
our
County?
Jurisdiction.
The matter out in Macomb County?
No, this our jurisdiction, I'm trying to tell you, and it really don't have to specify what lawyer said that, but I'm just telling you.
I'm not
I know for a
asking,
fact.
I'm not asking
Yeah.
for which lawyer said it. I'm just asking if it was a lawyer that was here. That was my
No.
question.
No. This was a paid lawyer on another.
And is that your lawyer?
You know, I mean, I wouldn't, it ain't nobody's lawyer, it just was retained one time, we never really, let's just say that. He got on the phone or something, you know, but anyway, it
Who retained him? Did you retain him?
was like a family thing, both sides of the family did it. Anyway, it don't matter because it ain't got nothing to do with this. But I'm just saying, but what does have to do with this is the fact that this person did say that she does not want to press any charges, that she wants to drop the charges.
Okay, sir,
And-
let me just clarify. I will let you know what's relevant or not relevant, or what pertains to this case,
Right.
okay?
Right.
I will let you know that.
Well, I'm just telling you,
No, I'm just telling you.
I got a kid with her, I mean, so I don't.
I am just telling you. I will tell you what I think is relevant or not. Okay?
Right.
The fact that there's a mutual attorney somewhere that you retained, somebody retained, means that you have money for an attorney.
No.
Second,
this was-
there-
this was-
Don't interrupt. Don't interrupt. Second, whether there's another matter in another jurisdiction may or may not be relevant to this court. This court will determine that, not you. Third, some random attorney that is not a part of this case has zero jurisdiction right now and zero standing as to what's going on.
Right.
So the fact that you chose to listen to an attorney that has nothing to do with this matter here in this court, as opposed to the attorney that's here today representing you, is not on this
But
attorney.
if I see it, him ain't seeing eye to eye, why wouldn't I seek out other representation or consultation?
You have that right to seek out representation
Mhm.
at your own
That's
cost.
right.
You absolutely have that right.
Right, that's what I just was bringing to the attention of the board.
That person is, sir, if you've not retained that person's services, they've not filed an appearance in this court, that attorney has zero relevance to this case.
Well, I will.
You can disagree all you want, but
I
I'm
know
telling
for a
you,
fact that-
I'm telling you, zero relevance. So whatever that attorney said, that she said or not, I don't know.
See you in trial, see you in trial, let's go to trial.
Your Honor,
So you want, okay,
I would like
you have the right to
Because
have,
I'm telling you.
you have the right to go to trial.
I
Excuse me.
think the truth don't matter here. It don't
Sir,
matter.
stop right now. Stop right now. At what point did you hear this court say the truth doesn't matter?
I've seen it.
No, that's your assumption. You're making those
I ain't
assumptions.
gonna make no more assumptions.
Because I believe, if you recall correctly, you assumed that you were going to be found responsible or guilty for your probation violation, which you were not. Correct?
Something like that.
Correct?
I guess you could say that, yeah, correct.
Yes, correct. So stop with those antics now. It's not getting you, stop, it's not getting you very far. So we're going to set this for another pretrial. I will tell you the date that Mr. Westmoreland will be here.
Your Honor, may I please continue our deliberation?
Yes, just one moment, just one moment. This court does not excuse him from being your attorney. But since you laid those allegations out, I'm giving Mr. Gopal an opportunity to respond.
What allegations did I lay out?
Sir, you accuse him of being racist, you accuse him of not doing his job, so I'm allowing him to respond to that without interruption.
That wasn't being treated there. Or
I am giving him an opportunity to respond to that without interruption. You may proceed, Mr. Gopal.
Thank you, Your Honor. I did speak with Mr. Kazak. Mr. Kazak indicated that the complainant was contacted, but it was not, or at least he indicated to me, and when I told him, because Mr. Howard Randolph had relayed this information to me, and I specific that she was not going to appear and was not going to consider this case and continue with the prosecution. That's what I relayed to Mr. Kazak. Is that correct?
Yes, Your Honor, Mr. Gopal was quite zealous and advocating for Mr. Russell, clearly explained clearly explained the defendant's position, clearly explained that the complaint did not want to cooperate, did not want us to prosecute, and that we should dismiss the case. Indicated that Mr. Russell not willing to accept this plea resolution, and that we should dismiss the case.
And Your Honor,
well, I do have one question though, Mr. Gopal. I'll give you an opportunity to respond. What's that, Mr. Howard Randolph?
He called me Russell.
He did.
I apologize.
Yes. So, how do you know, Mr. Howard Randolph? Can you please let me finish the question before you interrupt me again? Thank you. There is a no contact order for your bond condition. So how is it that you know that Ms. Duff does not want to proceed?
We have mutual friends. We know the same people. People talking the words clear like butter. So that's just what it is. I mean, I can't stop people from hearsay, can I?
So you don't have any confirmation from her mouth directly
Not
that she,
Melissa's mouth, no.
stop interrupting me, that she does not want to proceed. So it's all just hearsay. Is that yes?
You have something that comes from someone else's mouth that is hearsay, so I would say it's hearsay.
Okay, sir, I was trying, because you had a nonverbal response and that recording cannot pick up the nonverbal response. So I was trying to clarify that the answer was yes.
Can you repeat the question?
You have not heard from Ms. Duff's mouth directly that she does not want to proceed,
No, I
correct?
have not heard that from her mouth directly.
Okay, very good. Okay,
and Your Honor, after I received that, gave that information to Mr. Kazak. Mr. Kazak indicated to me that they had been in contact. However, based on his the reports and based on the fact that it's the people that are bringing the charges, that at this point in time, there would be no dismissal. And this matter could be either set for trial or an offer could be reached. I spoke to Mr. Kazak. Mr. Kazak told me what the offer would be if Mr. Randolph Howard.
don't interrupt, please. Just one moment.
representing me, he's not my lawyer. At this point, there's no reason for him to even be.
You have,
Stop, I'm gonna tell you this right now. The reason is because I'm giving him an opportunity to respond to your allegations. Stop interrupting everybody. Stop. He's not representing you at this point. He's giving this court a recitation as to what he has done because of the allegations that you've put forth on the record. So stop now. One more interruption, this court will hold you in contempt of court. So stop. You may continue, Mr. Gopal.
thank you, Your Honor. I then took this information back to Mr. Howard Randolph. I told him that even though they are aware that she's not going to prosecute or does not want to continue, it's the people who are bringing the charges. And so therefore, we're still at this pretrial stage. I also explained to him that an offer was made and the first words out of his mouth was, no, I'm going to trial. I said, I still have an obligation to let you know what this is. Told him what the offer was, and he said, no, let's go to trial. I then discussed with him his rights and told him, do you want to have a jury or do you want to have a bench trial? He immediately said bench trial. That was my representation. I've done everything I can to try and solve Mr. Randolph's problems. I have never. Okay. And Your Honor, his claims that he's made here are outrageous. I don't care what he thinks. I do indicate that he's claimed that I have not represented him because he's black. You've got to be kidding.
Okay, here's what the court's going to do. We're going to adjourn this May 25th at 8:30 a.m. You'll have a different attorney, Mr. Howard Randolph, unless you hire your own attorney, retain your own attorney, and that attorney files an appearance. As of now, the new date is May 25th for an adjourned pretrial. The bond and conditions are continued.
And Your Honor, I want on the record that I did file the discovery order and I did send that to him and we verified that this morning.
Okay, and Mr. Howard Randolph, you received a copy of that, correct?
Just now, yeah, sure did.
Okay,
It wasn't just now, Your Honor.
regardless, you received a copy of that, correct?
I didn't know I had a copy, but yeah, I did send it once I asked him to show me what.
Stop. The answer to my question, you have a copy of the discovery, yes or no?
Yeah, what's the problem?
Yes.
Why we gotta talk like
Okay.
this? I ain't-
Yes.
you know, wrong too.
Okay, so,
Personal, like you yelling at me, like you ain't yelling at nobody else, it was a thing, you yelling at me.
sir,
Like, what's the problem?
sir, there's no problem. I just had, I had a question. Stop interrupting. I asked you a question. It was a simple yes or no answer. Okay.
You yelling at me.
So, sir, I am raising my voice. I certainly am, because I'm trying to make sure that I have control of this courtroom when I'm continuously getting interrupted.
How am I interrupting by speaking my mind?
Because
Am I yelling at you?
you're speaking over me.
Okay,
and
you
inter-
yelling at me.
Here we go again. All right, we're done. Bond and conditions are continued. We're done.
Hey.
All right, we're going off the record, and then we're going to handle Mr. Elkins. Just one moment.
Thank you, Your Honor.
Because something you say could be used against you.
Mhm.
So that is why I indicated if your attorney suggests that you
I'm
speak.
saying nothing wrong. I'm just saying the Michigan Tender Commission needs to hear about this.
Okay, now I'm holding you in contempt. I've already indicated that you are not to interrupt this court, yet you have continued to do so. I've given you one chance. I've given you one chance right now. The court is going to indicate pursuant to MCL 600.1701 that you are engaging in disorderly, contemptuous, insolent behavior during the immediate view of this court and in the court's presence, directly tending to interrupt its proceedings and impair the respect due to its authority. Further, that under MCL 600.1701B, that this court finds you are in contempt during any breach of the peace, noise, or disturbance directly tending to interrupt this court's proceedings. The court will also indicate that this has occurred in the presence of the court. Therefore, the court may punish you summarily by fine or imprisonment or both. Stop interrupting, sir. Therefore, the court's going to indicate 15 days jail for contempt. The court's going to also indicate that while, sir, you were quiet and not interrupting this court's order, nor the proceedings, towards the end of the proceedings, then you began to interrupt this court. Despite this court's order not to.
Not to speak my mind.
Not to interrupt this court.
I didn't interrupt.
Therefore, as is evidenced still by your continued interruption of these proceedings, the only corrective action necessary to restore order and maintain the dignity and authority of the court is to hold you in criminal contempt and sentence you to 15 days jail.
Okay. But hey, you filed a false police report, you let it get in your courtroom, so did the prosecutor and the team.
Sir.
We'll hear about it, and it's already, you got
Sir.
a grievance on you already right now.
Sir,
And
you may file anything that you
June the
choose.
first, hey, listen,
You
this
may
domestic violence.
Stop interrupting.
You're gonna.
Stop
get sued.
interrupting.
I guarantee that.
Okay, well, at least you're helping the court make a record for yourself, for the court as well, as to why this court found you in criminal contempt. We'll see you next week on the
Rio, I love
17th.
you, baby.
You're not to
That's
address,
okay. I'm addressing the bar though.
Sir.
I'll make you that.
sir, the court's adding another 10 days time for you addressing the victim in this matter. The full 25 days are going to go on the record in the matter of the state of Michigan versus Shadid Howard Randolph, 23302. And appearance for the people, please.
And good afternoon, I'm
Good afternoon, Your Honor. Just checking here, you have my client.
Thank you. Your name, sir.
Shadid Howard Randolph.
All right, thank you. And today's the date scheduled for the adjourned bond violation hearing. And counsel?
Your Honor, today's time dates at the bond violation hearing are claiming witness, however, has not appeared. I'm going to ask the court to issue a show cause for her. She was subpoenaed to be here. She did request a subpoena be served to her electronically. I sent our victim sent to her electronically like Thursday or Friday of last week. I did receive a copy of the email she sent. She also CC'd the victim's attorney at that time as well. Furthermore, this court also ordered her orally to reappear at today's time and date, and that she would reappear for the show cause hearing, for the bond violation hearing. Here, so I will just ask the court to issue a show cause for her appearance. Based on that, Your Honor, and also the fact that we received some communication indicating that the defendant had contacted the point from the jail last Thursday on the 11th. I would ask the court to adjourn the bond violation for 1 week to next Wednesday. I believe that would allow us additional time to locate the complainant as well as to get additional records for that violation period during the jail, the call from the jail on the 11th by the
All right, thank you, Mr. Chairman.
Your Honor, I object to the adjournment at this time, Your Honor. At the last court proceeding, we were here for approximately 2.5 hours. Complaining witness failed to appear and that furthermore appeared on video. She indicated that she did not want to proceed. My client was put into custody. I understand that there was allegations of contempt. However, we are here now again, and the complaining witness did not appear. I know that this allegation stemmed out of a matter that may have happened in Macomb County in April, but to this date, I don't see anything verifying a charge against him. And as to calls made from the Wayne County Jail to the complainant, all I've seen is a potential email indicating that a call was being made. I see nothing beyond allegations. So I'd ask that the adjournment be denied, and at this time I'd ask for the matter to be dismissed and set for remaining at the bench trial.
All right, so the court will note that, yes, everybody was here for quite a while. On May 10th, there was concern as to where Ms. Duff was because she wasn't responding to any messages, emails, or phone calls. The court will note that Ms. Duff did Zoom in. Counsel objected to Ms. Duff testifying via Zoom. And so the court set this matter for an in-person hearing today. The court will also note that there was an email sent to the 27th District Court email indicating that there's an allegation that Mr. Howard Randolph contacted Ms. Duff from the Wayne County Jail phone the day after he was here in court. With that new information and the fact that Mr. Howard Randolph is currently in custody for contempt proceedings, the court is going to grant the people's motion, adjourn this. We're going to adjourn this 1 week. We're going to also issue a show, the court's going to also issue a show cause for Ms. Duff, and we're going to schedule this for May 24th at 9 a.m. Mr. Howard Randolph, I'm going to remind you that you are not to have any contact with Ms. Duff. That's phone contact, text message, email, social media, third party, package delivery service, whether it's FedEx, Amazon, any UPS, whatever it may be, United States Postal Service, nothing, no letters, nothing. Do you understand that, sir?
Yes.
In fact, didn't I say last time that there's a violation of putting him in solitary confinement? Or was
I
that-
don't have a recollection.
Okay, that may have been Mr. May have been a different individual. I don't have a note as to that effect. Anything else for the people?
No, thank you, Your Honor.
Anything else for the defense?
No, Your Honor.
All right, the court's going to indicate bonding conditions are continued, and we'll see everybody back May 24th at 9 a.m.
Your Honor, just on a housekeeping issue, I know that this is something that I want to bring to the attention of potentially, my client asked to be brought up. He indicated that on the second 10 days of contempt, that he was not talking to the complainant, but rather his son. Judge Brant, potentially we can look at the transcript and see what, or even potentially recording to see what name was called out. I know that we're.
Baby was the name. I love you, baby. That's what it was.
At this point, I'd ask that just that in the next week, there's consideration as to that, depending on the nature if there's no contact, because I understand he has 15 days, which means that he'll be in custody still on Wednesday, even if the 10 days were to be taken back today, correct, Judge?
Correct.
So I'd ask that I could revisit the second contempt charge at the next court proceeding, which would still be within the original 15 days, keeping him in custody, but potentially having that set aside. Is that something I could readdress with the court at that time?
Sure, you can readdress it on that date. The court does recall very vividly that as Mr. Howard Randolph was being transported away from the podium, that he looked at the screen and yelled, "I love you, baby." And that the only individual that was there at the time was Ms. Duff.
I do believe there's a baby crying, but
Correct, the only one that was on the screen was Ms. Duff. So,
and I'd ask that we could revisit that potentially at the next court proceeding.
you may, yes.
Thank you for the consideration, Your Honor.
All right, thank you. We'll be off the record.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.